Lordship, I beg your permission to move and listing a case today itself. Lordship, tender matter. If possible, Lordship, last item.
Today,
Lordship, last item, Lordship.
have you filed it?
Lordship, on 11. It is filed on 11.
11th. Then it can come up on Monday.
Lordship, it does not come. That is why I have to mention, Lordship. We have tried in the registry. If possible, Lordship.
Okay.
May it be please, Your Lordship,
Oh.
with the concern of other side, I beg to mention item number 2, my lord.
Oh.
Arguing counsel, Mr. A.K. Bura lost his father recently, my lord.
Oh.
Kindly adjourn the matter for 3 weeks.
Lordship, I'm praying for 27th, Your Lord. There's some urgency on a part, Lordship. There's an interim
Is
order.
it for the vacation of the interim order, isn't it?
Lordship, there's an I-4. 27th, Your Lord.
Can he come by 27th?
The ritual should be over by that time.
That time it will be over? Okay.
27th.
Okay, item 2. On request made on behalf of Mr. A.K. Barwal and a counsel for the petitioner. List on 27th.
27th.
Okay.
My lord, there is an interim order, my lord.
Okay, interim order passed in WBC number 6994. Interim order passed in the main petition to continue till the next return date.
May I please, Your Lordship?
Yes.
Lordship, there is already submitted an adjournment slip for item number 8, Lordship. Requesting for 2 weeks time, Lordship.
Item 8.
Yes, Lordship.
Okay. You're appearing on behalf of?
M. Mahanda.
On request made on behalf of Mr. M. Mandal and the counsel for the petitioner. List after
2 weeks,
2
Lordship.
weeks.
Obliged.
May I please, Your Lordship? I beg to May I please, Your Lordship? I beg to mention for listing one contempt matter, Lordship. 17 or 18, Lordship.
Oh, no.
I need it.
We'll have it on 21st.
Much obliged, Lordship.
May I please, Your Honor?
Yeah.
Like to mention for listing of a writ petition on Wednesday, Lordship. 19.
Okay, 19th.
Lordship.
All right.
Obliged.
Item 1 of daily list, motion.
But please.
Hmm.
The petitioner, he has been awarded contract for improvement and upgradation of road. And till date, he has completed more than 30%. When he went to the submit his running bills, it has been informed that the forest royalty will be deducted. Then
What will be deducted?
forest royalty.
Forest royalty.
Thereafter, the petitioner on 23/2024 filed a representative before the authority. And on the other hand, the matter is already settled by this honorable division bench of this honorable court. So may I pray for my similar order, my
Who appears on the other side? Forest.
These are the similar orders passed in different cases.
Let us see.
Yes.
You have any instructions?
My lord, here forest department will have to be a proper party.
No, is the forest department a party here?
No,
It's
no,
not a
my-
party, man.
not required, my lord, since forest department has no locus entity to deduct any.
The money goes to forest department, lord.
No, that's why forest has to be there.
No, my lord, it is the respondent, my lord, who have deducted the amount and then given to the forest department. Already decided, my lord. Two different orders, same party, same petition.
Where's the order? Oh, deduction of your forest.
My lord, there is no in fact order.
Oh, okay.
They have informed us, then we file an representation page,
Where's your representative?
page 154, my lord. Dated 23, 2024.
23 or 28?
28-3. Page 154, Annexure 8.
So let him consider the representation.
Yes.
That can be done.
Oh. Okay. You are appearing for
A PHA department, Lord.
PhD department. Heard Mr. PG Cycle and a counsel for the petition. Also heard Mr.
I bought it.
I. Botako and a standing counsel.
PH.
PHE. PHE or PWD?
PHA. Lord.
There's no PHE here.
Public. PWD. Item 1.
PWD is the counsel.
Then Lordship PWD council will be required.
So you are not involved.
Lordship, I was referring to item 2, Lordship. It's the same. That involves PHA.
Okay, item 2 has been adjourned.
Right.
Okay, who appears for PWD then?
Earlier, one A. Saliha was appeared,
A. Chalia?
my lord. His name may be recorded.
Without his consent, how can we dispose it of? Unless he's present. You catch hold of him and come. A. Chalia. Okay. We take out after some time.
12 of supplementary list, motion.
I think.
Yesterday, my lord, thought for a, that my lord, cancellation of my settlement, my lord, without hearing me, my lord.
Who was it? Council as data, PNRD.
He's here for me. Put him.
Let your junior go and
Yes, ma'am.
catch hold. We'll take
Yes,
up
sir.
after some time.
13,
Just for time being, my lord, my senior, yes, Chaudhary, my PK Roy Chaudhary is in another court, madam.
After some time.
free of daily list, admission.
Actually, kindly pass over for some time.
Why?
Actually, my senior is coming.
Where's your senior?
Our day.
I appear for PHA.
Okay. Affidavits come? Not yet.
Lordship. Here also, Lordship, Forest Department would be required. because
With regard to the forest royalty only, this also.
Forest royalty, Lord.
Okay. After some time.
12, item 12,
12.
He's in outside.
My lord, as per the instruction matter I've just received, the matter was, my lord, after receiving the complaint, it was sent to the BDO for inquiry, my lord. BDO will take an inquiry, my lord, in a short period, my lord, thereafter. it
But
will-
already they have punished me, my lord.
Then how do you keep it in abeyance without the inquiry report?
That part I leave it to lordship, my lord, but within a week, my lord, this inquiry will be complete. That part.
That is only for 1 month, my lord. Only
Up to 31st.
31st December, 31st January, but 31st
March.
March, my lord. I will get only 4 days, my lord. because bi-weekly market in twice in a week, my lord.
Lordship,
Already, my lord, without trial, my lord, they have punished me.
I cannot submit, my lord, but Lordship may interfere with the abeyance
Abeyance
part,
order, my lord.
but enquiry part.
My lord,
Lordship may
inquiry part
directly
going on,
raise.
my lord, abeyance part might be fine. Annexer 3 is the notice, my lord, and that was the notice for auction, my lord. And then, my lord, Annexer 4 is, my lord, my
Okay,
allotment order.
heard Mr. TJ Mandal and the senior counsel. Assisted by MS P. Sharma and counsel for the petition. The executive officer, Moirabari Anchalik Panchayat, issued a notice on 27 to 2025 for temporary settlement of Moirabari bi-weekly market and Moirabari daily market through open duck for a period of 1/3/2025 to 31/3/2025. Stop. Pursuant to the notice dated 27 to 2025, the petitioner participated in the auction, isn't it?
Yes, participant in open duck, yes,
So participated in the open duck,
on 28th.
and you were selected,
Yeah, yes, my lord. I was the highest bidder.
and as the petitioner
I was
was
selected
the,
for bi-weekly market only.
was the highest bidder, was selected for the Moribari bi-weekly
Bi-weekly
market. Stop.
I deposited the money on, my lord.
How much did you deposit?
I have deposited, my lord, 6,68,100.
And accordingly, the petitioner deposited an amount of rupees 6,68,100 before the Morigaon Zilla Parishad. Correct?
My lord.
Stop. Then what happened?
Then, my lord, I have run for two days, I have running.
While
Then one
while
complaint, my lord.
the petitioner was running the Moribari bi-weekly market,
But
comma,
on 3/3, my lord, a complaint was brought.
Page 30.
Page 30 is the complaint, my lord.
one, what is the spelling?
Shah Alam Sarkar.
Is it correct? This SAH.
SH.
Check up in the vernacular.
Saha Alam.
Saha.
Saha. My lord, this is Saha Alam. Yes, Saha.
SAHA.
Yes.
One
Saha.
Saha, huh?
Saha Alam Sarkar.
Alam Sarkar made a complaint before the Chief Executive Officer, Morigaon Zilla Parishad on 3/3/2025. Stop. Where's that abeyance order?
Annexer 6, page 35, my lord. 5th March 2025.
Draft, comma. The Chief Executive Officer, Zilla Parishad Morigaon, by a communication dated 5th March 2025, directed the executive officer, isn't it?
Yes,
My
sir.
lord.
Moribari Anchalik Panchayat to cause an inquiry into the allegations made against the petitioner. And where's the abeyance? I have not seen
And
it.
the last line of the last but one para. Therefore, you are requested to cause an inquiry into the matter
And
immediately.
during the pendency of the inquiry,
Direct the settlement.
a direction was issued to to keep the settlement process of both the market in abeyance.
Abeyance.
Stop. Para. No, draft by an order dated 7/3/2025. The executive officer Moribari Anchalik Panchayat appointed 4 employees to collect the revenue from the Moribari daily and Moribari bi-weekly market. Stop.
And my lord, serial number 8, my lord, there is a direction not to collect by me. That is the only communication to me, my lord.
Further, comma,
Serial number 8, my lord. Copy 2.
the said order was also endorsed to the petitioner with the direction not to collect the revenue from the Moribari bi-weekly market
With
with
effect from
effect from 8/3/2025. Stop. Para. Learned Senior Counsel for the petitioner submits that the communication dated 5th March 2025 by which the settlement in respect of the petitioner with regard to the bi-weekly Moribari bi-weekly market has been kept in abeyance, and the order dated 7/3/2025 appointing 4 employees to collect, entrusting 4 employees to collect the revenue from the Moribari daily and Moribari bi-weekly market is in violation of the principles of natural justice, inasmuch as the inquiry to be conducted is yet to be completed, nor was the petitioner given an opportunity of being heard. Stop. Para. No need to issue notice, I think.
Yes, my lord.
Hmm?
Lordship can dispose it of, my lord.
No, I'm not disposing it off. Let the inquiry be over.
Yes.
Mr. S. Datta, Leonard, Standing Counsel,
Yeah.
PNRD Department, submits that the inquiry is presently being conducted by
Executive officer, my lord.
the executive officer,
Moirabari Development Block.
Moirabari
Development Block.
Develop
Anchalik Panchayat.
Anchalik Panchayat,
Respondent number 7.
public respondent number 7. And the said inquiry would be completed within a period of
1 week.
1 week. Stop. Accordingly, comma, list the matter on today's what? 13th. We'll have it on 21st.
Well.
List the matter on 21st March 2025. Stop. Till the next returnable date, comma. The order of abeyance, the communication dated 5th March
5th March.
2025
And
issued by the Chief Executive Officer Zilla Parishad Morigaon, keeping the settlement in respect of the petitioner with regard to the bi-weekly,
Bike.
with regard to the
Moribari bi-weekly.
Moribari bi-weekly market in abeyance shall remain suspended.
And consequently, my lord,
So, however, it is made clear that the inquiry directed in the said communication dated 5th March 2025 would continue. Stop. That much.
my lord, but consequently, my lord, the 7, I may be allowed that 7/3, my lord.
Consequently, the order dated 7/3/2025
He
is also
My lord.
shall also remain suspended.
Deeply.
Next week.
One of daily list, motion.
Let's say in this case, I need some time to furnish instruction.
Why?
It's Monday, Lordship. Monday,
You want it on Monday?
Lordship. And
Otherwise, it's
otherwise, just division bench judgment take there.
then what more? What instructions do you want?
Up to Lordship will pass order.
We'll pass order. It considered a representation that all.
Oh, Lord.
I'm not saying any.
Lord.
Earlier order also is the same
My
thing.
lord.
Heard Mr. P.J. Saike, learned counsel for the petitioner. Also heard M.S.
Yes, Sharma.
H. Sharma,
For
learned
all the response.
standing counsel, PWD.
PWD.
PWD for all the respondents. Stop. What is the work that they have been awarded?
Improvement and upgradation of road.
Where's the work order?
Work order is my lord at page. Page 151, my lord. Letter of acceptance, page 22.
This is a petitioner's firm.
My lord.
Okay. The petitioner's firm was given a notice to proceed with the work on 14/3/2024 by the Chief Engineer, PWT Roads, Assam, in respect of improvement and upgradation of roads from Sartipari to Naugong, from what is this? 0.000 kilometer within brackets Sartipari. You'll get it in page 151, huh? To CH 14.420 kilometer within bracket Naugong under Assam Mala 2.0 for the year 2023-2024. And package number so and so, huh? It's in this thing. I've just marked it. Page 151. Stop. At the cost of rupees,
40,
for an amount of rupees
40 crore, 4 lakh.
40,04, 49,870. Stop. How much work have you completed?
30% has already been completed.
The learned counsel for the petitioner's firm submits that the petitioner had completed approximately 30% of the contract work till the month of
My lord, page 152, my lord, this is report of the my lord, progress report. My lord.
this is which month?
It is of my lord 19/2024, my lord, to 16/4/2020.
Till the month of
April 2020.
April 2024. Stop. Accordingly, the petitioner submitted his running bill.
My lord.
Running bill.
My lord, but when the petitioner went to submit his earning bill, the office of the
okay.
respondent said,
However, when the petitioner went to submit his running bill, the petitioner was verbally informed
yes,
by the respondent number
4, my lord. Executive engineer.
by the respondent number 4, Public Executive Engineer, Public Works Department within bracket roads, Barpita, Mandia and Chengal Territorial Road Division, Barpita, Assam, that forest royalty would be deducted from the running bills of the
Yeah.
petitioner. Stop. It is the case of the petitioner that in terms of the judgment and order,
Reported in my lord 2013.
in terms of the judgment passed in the case of Trinian, isn't it?
Yes.
Associates within bracket MS and another versus State of Assam reported in 2017 2 JLT 859, as well as division bench order is what date?
Division bench order is page 163.
Well, there are two orders, madam, at 158 and page at
163.
163. On the same issue. That forest royalty cannot be deducted from it.
As well as in the case of State of Assam and others versus Muslim Ali within bracket MD, reported in 2013 2 GLT, correct?
Yes.
945. The PWT cannot deduct forest royalty under the Assam Minor Mineral Rules 2013 unless there is a clause to that effect
In the contract.
in the
And
agreement executed between the petitioner and the PWT. Stop. Para. It is the further case of the petitioner that the petitioner has submitted a representation
158. I'm sorry, madam, 154.
before the respondent number 4 on 28/3/2024, correct?
My lord.
On
Correct.
28/3/2024. Not to with a not to deduct the forest royalty against the earthwork from the running bills of the petitioner. Stop. Has it been considered?
No, madam.
However,
Not yet.
comma, till date, the representation dated 28/3/2024 has not been considered by the respondent number 4. Stop. Learned counsel for the petitioner accordingly submits that the writ petition can be disposed of, directing the respondent number 4 to take a decision on the petitioner's representation dated 28/3/2024 within a specified period of time. Stop. Para. MS S. Sharma,
Yes, sir, ma'am.
Learned Standing Counsel, PWT, appearing on behalf of all the respondents, has no objection to the prayer made by the petitioner's counsel. Stop. Para. Accordingly, this writ petition is disposed of with the direction to the respondent number 4 to take a decision on the representation dated 28/3/2024 made by the petitioner within a period of
Within a period of 6 months.
no representation considering the
Already
Sorry, Lordship.
15 days
1 month.
within a period of 1 month from the date of receipt of a certified copy of this order. With the above observations and directions, the petition is disposed.
Obliged.
Three, admission.
My lord, this petition can be disposed in similar terms, my lord. Let the chief engineer.
Only thing, my lord, here, in the earlier case, my lord, the amount was not deducted. In this case, my lord, the amount was deducted. And the amount of 87,615 has been refunded. We have claimed for refund of the amount. My lord, my condition is that, my lord, since it is a, my lord, the work orders issued towards my construction of a, my lord, water supply scheme, my lord. Certain things were purchased from the market, my lord, where already we have paid tax. Now, enter supposing, my lord, a pump set. We purchase it from the market. Now, what has happened, my lord? From the gross amount of the mill, my lord, 2% has been deducted. No, I cannot be, my lord, impose royalty against a water pump, my lord.
Yes.
For that, my lord, there is an instruction from the forest department saying that wherever it is thought that forest produce is utilized, either they will have to produce a certificate saying that it has already been paid.
So can we, but then here is the case where you've already deducted the forest royalty, correct?
Yes.
But my lord, after consideration, if it turns out that because some new judgments have come up, based on that, lordship, if it turns out that it was an unnecessary deduction, it can be refunded, lordship.
If your lordship,
Let the chief engineer pass a reason order, lord.
Whom did you make the representation?
that is your lordship will find it page, executive engineer, my lord, page 33.
Page
33. And lordship will find the deduction at page 27, lord.
This also a running bill,
No, my lord, the final bill.
final bill.
Yes, my lord. Work was handed over way back.
Where's the thing?
If your lordship,
Deduction?
deduction, your lordship will kindly come to page 27. Your lordship will see clause 6, forest royalty, an amount of 87,615.
Close.
Roman 6, my lord. On the
How much
left,
is
my lord,
this?
87,615, my lord.
Huh?
On the left, my lord,
Oh,
87,615 plus 6 royal forest royalty.
but on the right side is something else.
No, that is the amount, my lord, 87,615.
Okay. 87,615.
And the representation your lordship will find at page 33.
Where's the work order?
Work order will annexure 1, my lord. Sorry, annexure, just say. Page 16, my lord. 1621. My lord, lordship will find it annexure 3, page 25, my lord, the handing over and taking over.
Page.
Page 25, my lord, and it was handed over on 25/5/2023, my lord,
After completion.
after completion, my lord. The original will find it page 26, my lord.
Okay. What, Mr. Arde? Learned counsel for the petitioner. As well as Mr. I protocol, learned standing counsel,
PHE, lord.
PHE. All the respondents,
All the respondents.
including respondent two,
Respondent to also, lord.
appearing on behalf of all the respondents. Stop. Para. The petitioner was issued a work order on 1/6/2021, correct?
Lordship.
1/6/2021 by the civil engineer within bracket PHE water cum additional mission director JJM Assam for implementation of different pipe schemes under Dibrugarh PHE division for retrofitting under the program of Jal Jeevan Mission Assam. You get in page 16. Stop. For an amount of rupees 3,49,90 lakhs, correct?
Yes, ma'am.
90 lakhs.
Page 24, my lord, the amount was revised to 5184. 51,84,000.
1 minute.
Certain additional works.
Not-
were done.
It's 3 crore.
Yes, my lord. This,
Look at page 16.
no, my lord, your lordship will kindly come to page 24 then, my lord. 3 lakhs, 3 crores 49 lakhs, 49 lakhs 90,000 only, my lord. Now, against the scheme, my lord, page 24 is the amount, my lord. There were certain additional works and
No, the first amount.
the approximate value of the of the entire work, my lord. That is the entire work, my lord.
Oh,
That is for the entire work, and your lordship will kindly come to page 24.
oh,
My bill relates to this one, my lord. The amount was revised, additional works were there.
so this is the main work order?
Yes, my lord, 51, my lord.
Wait,
This is the revised work order.
so you're claiming on the basis
yes,
of
yes,
revise?
yes.
Okay, then you say was issued a revised work order, huh?
Yes,
Oh, no, was issued a revised work order for retrofitting of Motok Barta PWSS for implementation of JJM Assam during the year 2020-2021 under Dibrugarh within bracket PHE division for an amount of rupees 51.84 lakhs by the superintendent engineer within bracket PHE Dibrugarh Assam Dibrugarh. That's on page 24 here. Huh? Stop. The petitioner accordingly completed the work in terms of the work order dated 12/1/2023.
it will be the earlier work order, my lord, because it is a continuation of the earlier work order.
Okay,
So,
completed the work and handed over on,
on 25/5/2023, my lord.
where is that?
Page 26.
Where's the date?
In second paragraph, my lord. I have completed all the works of the sales, so and so.
On 25/5/2023, correct?
Work was completed on 13/3/2023, handed over on 25/2/2023,
Completed the work on 13/3/2023
and
and handed over on
25/5.
25/5/2023.
Lordship.
Stop. Thereafter, comma, while making the final payment to the petitioner, the respondents, the respondent number, the executive engineer, PHE, respondent number
5.
5, deducted an amount of rupees 87,615 against forest royalty from the total bill of the petition. Stop. Being agreed, comma, the petitioner made a representation before the respondent number 5 on 25/7/2023, praying for refund of the forest royalty, which was deducted from the gross amount of the petitioner's bill in respect of the work done by him. Stop. It is the case of the petitioner. Learned counsel for the petitioner submits that in terms of the judgment passed in the case of Trinayan Associates within bracket MS and another versus State of Assam reported in 2017 2 GLT, as well as in the case of State of Assam versus Muslim Ali within bracket MD reported in 2013 2 GLT. You got the citation, no? Page 94, I think. 2 GLT 94. The PWD. No, is it a PWD?
PHE,
The PHE department cannot deduct forest royalty under the Assam Minor Mineral Rules 2013 unless there is a clause to that effect in the agreement executed between the petitioner and the PHE department. Stop. Para. Learned counsel for the petitioner also submits that the representation made by the petitioner on 25/7/2023 is also yet to be considered by the respondent number 5. Stop. He therefore submits that a direction be issued to the respondent number 5 to consider the representation dated 25/7/2023 made by the petitioner and and to dispose of the same within a specified period of time, with a further direction that if the petitioner is entitled to the refund, the same be made uh, at the earliest. Stop. Para. Mr. I. Bartukol, understanding counsel PHE, has no objection to the prayer made by the petitioner. Stop. Para. Accordingly, this writ petition is disposed of. Directing the respondent number 5 to consider the representation dated 25/7/2023 and to dispose of the same within a period of 1 month
1 month.
from the date of receipt of a certified copy of this court's order. Stop. While disposing of the representation made by the petitioner, comma, if the petitioner is found to be entitled to the refund of the forest royalty as claimed by him, comma, the same shall be paid, shall be refunded within within the set period of within a period of 2 weeks thereafter. Stop. With the aforesaid observations and directions, with petition is disposed of.
Problem.
4.
Matter will be taken after some time again.
Why?
In this case, senior advocate K. N. Sudhir sir will appear. He is in election court number 1.
Case, your lordship directed me to produce record, malan, at last occasion, malan. On 5th, malan.
Okay.
K. N. Sudhir sir will appear, malan, after some time, malan.
I'm told, malan, that I have some supporting documents has been sent, malan, on 10th. And on a query, malan, I could learn that, malan, that original record has been seized by the police authority, malan.
How?
Because there is a police complaint against the person, malan. So they have seized the record, malan. So some documents they have sent, malan, in support of the case, malan. But record is
Just-
seized by the police.
Just call for the report in respect of show cause notice, whether serve or not to the petitioner.
It's not
that
with us now, malan. That
Yes,
is
that-
the, malan.
Okay.
And our case is that we said, but malan, to substantiate our submission, malan, record is now not with us.
So how do we get the records?
I'll have to talk with them, malan. Can it be taken up next week, malan, so that
Tuesday?
if possible, malan, I do not know what is the stage of that, malan, inquiry or malan thing. So maybe we fix on next week, malan. And if it can be produced, then I'll produce, and it can photocopy we can get the.
Oh, you
photocopy
can
of the
get the
original,
photocopy.
Scan copy or
Oh.
photocopy, malan. So
Okay.
maybe in the next week, malan, on 19th or 28th, malan. So that
Okay, then.
malan.
The 19, my lord. In this case, earlier, my lord, earlier 2 occasions, my lord, similar
Okay.
report was called.
Heard,
my lord.
Mr.
No,
AK Azad, my lord.
AK
AK Azad, my lord.
Azad,
Yes.
Learned Counsel for the petitioner. MS Udas, Learned Government Advocate. Appearing for the state respondent submits that the records has been seized.
As per telephonic instruction, says, malan.
Submits that on the basis of telephonic instructions received by her,
malan,
the records have been seized
malan.
by the police. Stop. She, however, prays for a short time
19, my lord.
to enable her to produce the photocopy oblique scanned copy
Copy.
of the said reports,
Malan.
of the said record. Stop. Accordingly, list
19,
this
madam.
matter on 19.
19.
Lordship, there is a IA, your lordship, number 548, your lordship.
Mm.
My prayer for dispose of the IA for implete petition, your lordship. We are the dealers, your lordship, of the Samawar. Petition is secretary.
In respect of IM, my lord, what happened? Whether they are necessary party in this case or not. On that question, on last occasion before the coordinated bench of this honorable court was raised, but that court was not allowed, my lord. In respect of hiring of IM, my lord, I have to
We are the dealer, your lordship.
call for my senior, my lord, in respect of IM.
Okay, then let us take up on the 19th.
19th.
Master blessing.
5. Hearing.
What is this? कौन है? Yes, CKS Barua.
Before I begin, naturally, my lord, I will look towards the right.
Ah.
So,
I have informed my lord that.
This has been kept pending for a very long time. Now we have forgotten what we have argued on.
naturally, I'll refresh your lordship's memory, but then somebody should be there from the government side.
If he is not available, you can appear.
But we have to that certification. I tell my lord, I'm
If
coming
she
after
undertakes
the-
the responsibility that next time she will appear, then my lord, I'm willing to concede. Next time she should appear.
I make my lord.
What? What is it?
Please,
I don't know. You'll make me sit for the whole day. And finally, nobody will appear. Next time you appear,
Or we do one thing,
again,
My lord.
we'll fix it on Tuesday
let me,
Next.
my lord.
or
I cannot be available.
on a convenient date
Yes.
to the parties.
My lord.
On that day, you make alternative arrangement if CKS is not going to, cannot come.
My lord, I'll.
My lord, in that case, let this matter go to the month of April. Let it be in the month of April in that case.
Heard Mr. B.K. Dewari, Leonard, senior counsel, assisted by A.R. Gogoi, Leonard counsel for the petitioner. On request made on behalf of CKS Barawa, Leonard government advocate, list the matter on
The 10th of April, Thursday. I hope it's not a holiday.
okay, yeah, 10th April.
Okay, love, before the, just before the Bihu. Because Bela Kise is on 1st of April. The 3rd of April, 3rd April, Bela.
Okay, 3rd of
Ah.
April. Oh,
Or since you appear, so it is me on All Fools Day. You know, it could be on All Fools Day also.
Yes,
that-
Thursday.
huh?
That is Tuesday.
Okay.
All Fools Day is Tuesday.
No, Monday, sorry, 1st of April, yes.
It's your choice.
But I have no difficulty. He will appear on 1st of April in future. Now Usha is going to appear, so
Okay.
I'll inform them. I'll it is next 1st of April, sir.
So we are fixing it on
1st April.
first.
1st of April.
First.
I'll-
6.
I'm sorry, my lord. Item number 4, there is the interim order, my lord. May
Item?
continue. Item 4, my lord. Interim order is that continue in next.
In the writ petition,
Yes, ma'am.
interim order passed in the writ petition to continue until the next writ.
Master bless.
6.
Actually, the RB Fukan is in this matter.
Hmm.
He is on like in another court. There's no difficulty on this part anytime next week or after any time as per your lordship convenience.
Lordship, they have not been paying the as per municipal wages. They have not been paying since last more than 2 years.
Okay,
That may be there.
Any
Direction may be given with.
okay, on request made on behalf of Mr. R.B. Fukan, then the counsel for the petitioner. List the matter on.
Next week.
Yes, Sharma. Yes, anytime as per his convenience, your lordship convenience.
Next week,
Tuesday and Thursday is allowable.
Thursday.
20 March.
Obliged.
7.
May I please your lordship,
Hmm.
the lordship may kindly pass over for pending your lordship.
You are appearing for
On behalf of BK Sen, for respondent number 1,
BK?
Sen.
Hello, let it come on Tuesday in that case.
You are appearing?
Yes, madam.
Oh.
Madam, I am appearing for the workman.
Respondent 1.
Yes.
Oh,
Therefore, management,
oh,
my lord, I have been terminated from service in most arbitrary manner. And
Bhatti, you are ready?
yes, I am present.
You are ready?
But otherwise, I am ready, my lord. My senior friend has
Short some accommodation, my lord.
No, I'm not going to
Tuesday.
seek any accommodation. When
My lord,
she,
he uttered Tuesday, my lord. That's why I'm.
no, Tuesday means when
Means-
she mentioned that
Uh-huh.
for the time being it has to be passed over.
Correct. That's correct. If it's not convenient to you, it's up to you.
My lord, otherwise I am ready, my lord.
Otherwise, what does it
Sir,
mean?
my lord, if your lordship take up the matter, my lord, I am ready. Otherwise, it is very all pending matter.
Oh, that's why I'm saying 2018 matter.
My lord, that is why.
So you proceed if you're ready.
Yes.
May it please your lordship. My lord, by this petition, I have challenged the validity of the award dated 2/4/2018, passed in reference case number 5 of 2006
1 minute.
by the learned labor court, holding the termination of page, my lord, at 90. This is the order, my lord. And prior to coming to this order, my lord, what has happened in this case? The award was earlier passed on 9/3/2009. Subsequently, I challenged that particular award in this honorable court, and this honorable court remanded the case back to the trial court, my lord. And that's why, my lord, I am ordered at page 90, my lord.
Hmm.
May I read it, my lord? The
Hmm.
judgment. Page 90.
Hmm.
May I read?
Yes.
An award in this case was passed by my predecessor on 9/3/2009, and the first issue of reference was decided in negative, holding that the termination of workmen Hitram Rajvanshi from service behavior by management is not justified, and the second issue of reference was answered in affirmative, holding that the workman is entitled to reinstatement with 30% back wages and also full wages for the period from 1/8/99 to 24/99. Being agreed by the Sedeva, the management, Mr. Hotel Azman, preferred a read appeal before this Honorable Guwahati High Court. The rest appeal was registered as such and such. The Honorable Guwahati High Court disposed of said writ appeal. It is not the writ appeal, my lord, writ petition. On such and such holding that in view of the inconsistent inclusion of the learned labor court, this court deems it appropriate that the end of justice could be met if the matter is remanded back to the learned labor court for a fresh adjudication based upon the evidence which is wrote in record. In Paraton, it was also held by the Honorable Guwahati High Court that it is provided the labor court shall take into consideration all the facts and materials of the record and arrive at a conclusion as to whether the workman had left his job on his own volition or not. By the court's judgment, the Honorable Guwahati High Court wants to re-evaluate the evidence and to decide whether the workman had left his job on his own volition or not by this court. Before this court, the case of the parties was that this court has received a notification number by Joint Secretary, issued by the Joint Secretary to the Government for some Labor and Employment Department dispute, wrapping the matter with two issues which are agenda, whether the management of the is justified in terminating service Hitram Rajvanshi with effect from circumstances and not. If not, whether the workman is entitled for reinstatement of service to full back wages. On the receipt of that notification, this court issued notice to the management of the Hotel Rajmahal and the workman Hitram Rajvanshi in the witness in the written statement filed by the management of Mr. Hotel Rajmahal. It was stated the workman Hitram Rajvanshi was appointed as bail boy on such and continued in such service till 71/3/99. The workman, without obtaining leave and without informing the management, stopped attending his duty. With effect from 1/8/99, on inquiry, it was found that the workman had gone for a better job elsewhere. However, the management, by letter number 7 asked the workman to join his duties by 10 a.m. on 16/8/99. Otherwise, he would be treated as absentee without information and would be deemed to have resigned from service under close condition of the restraining order. The workman did not intimate the management within the stipulated date. The management order Rajmal then again issued a notice and extend the time of joining by the workmen till 1999. They were again failed to comply with the said intimation. Thus, the service of the woman Hitram Rajman is terminated with period from 1/8/99. After keeping silence for more or less 4 years, the workman Hitram Rajman filed a complaint on A1132 the Assistant Labour Commissioner Government of Guwahati alleging illegal termination of his services. Before the Assistant Labour Commissioner, the management submitted that the workman was terminated with effect from 1/8/90 after service of 2 notices. It was reflected in the complaint appeal filed by the workman on 4/11/3 to the Assistant Labour Commissioner that the workman is not interested in reinstatement with back wages, but only interested in obtaining a compensation. The management prayed for dismissal of the claim of the workman on the ground that the workman Ikram Raj had left his services at his own volition. The willful act of the workman and a continuous absence of about 4 years do not warrant a holding of any kind of dramatic inquiry. The requisition filed by the workman Raj speaks that on 1/5/90 he was appointed and the services was confirmed on such and such identity card was issued and contribution against the ESI scheme was deducted from his wages. The management hotel Rajmahal is a partnership firm and the partners were Sri Kamal Sanjay and Sri B.M. Setia, Sri N.K. Setia. The hotel management was to be run for 5 years by each partners, and for the 5 years it was run and managed by the President Procedural Setia, who is the eldest son of Sri Keshijan. For the second term, the management of the said hotel was run by Sri B.M. Setia, and for the third term it was run by Sri N.K. Setia. Sri N.K. Setia has no son, and his term was taken over by Sri Sunil Setia. Thereafter, the said hotel was run and managed by Sri Devendra Setia, the eldest son of Sri B.M. Setia, Sri Sunil Setia, and Manoj Setia, son of Sri Keshijan, thought that the workman Sri Hitram Rajvanshi to be as the spy of Sri Devendra Setia. So Sri Manoj Setia directed the workman to hand over the uniform of the hotel to the housekeeper department and intimated him that as soon as their internal dispute is over, he would be called back. The Manoj Setia and Sri Sunil Setia asked the workman not to attend his duty with the 25/8/99. After expiry of leave, the workman reported for his duties to the office of management and Sri Sunil Setia. They asked the workman again to go and leave for another 3 months. On such and such, the workman reported for his duties in the office, but the management did not accept his joining report on the ground that the internet cover has not been over. On such and such, the workman reported for his duties, but he was informed that he would be informed about their position positively before such and such. As the workman did not get any intimation from the management of the workman made the proprietor partner of the hotel. The management of the hotel informed the workman that his services was terminated with effect from 25/5/99. Then the workman demanded termination order and informed that he will report the matter to Assistant Labour Commissioner, Government of Assam for necessary action. The Manoj Setia for the management told the workman that the matter need not be brought to the Assistant Commissioner and he will be paid a sum of 75,000 compensation. But the management did not pay the promised sum to the workman. It was alleged in the written statement filed by the workman that the notice alleged to have been sent to him are false and fabricated documents, and its process of termination from service was against the law. Therefore, the workman demanded reinstatement with back wages and other benefits with effect from 25/8/1999 and also for the wages for the period from 1/99. Before the court, from the side of management, 3 witnesses were examined. K.R.C. Manoj Setia, one of the partners from the Raj Kamalan company as PW1, Shri Kamendra Bo, Assistant Manager in charge of Front Office for Mr. Rajmahal SPW2, and Shri Narayan Chandra Saha, Head Cashier, Hotel Rajmahal SPW3. They were cross-examined. Government is the advance evidence before the court. He was thoroughly cross-examined. In his written evidence, PW Manoj Sheikh stood by the facts stated in the written statement filed by the management of Hotel Rajmahal before this court regarding the fact that the jailboy is stopped attending his duties from such and such, and a notice was sent to the workman asking duties by 10 a.m. on such and such. In the said notice, it was also stated that if anything otherwise happened, he would be treated as tenancy without information and would be deemed to have resigned from the services within clause 27 of the standing order. The workman did not turn up by 16/8/99, so management also issued a notice giving a further time for joining, but the workman did not respond. So the service of the workman is terminated with effect from 1/8/99. The workman brought a complaint before the Assistant Labor Commissioner on 4/11/3. In his written evidence, it was made specific the workman status Hitram Rajvanshi was terminated purely on his ground of absence. He denied the fact of asking him to take leave on the ground of following internal dispute between the management partners of Hotel Rajmahal, and also the promise to pay compensation of a sum of rupees 75,000. PWC Samendra Bose stated in his written statement that in evening of such and such, the workman intimated him in presence of Mr. Narayan Shah, the then head cashier of the Rajmahal Hotel, that he got a better job and he would not come to the hotel to join his service from the next day. He reported the matter to Manoj Kumar Chetia on such and such. Mr. Narayan Chandra Shah stated in his that on such and such, Hitram Rajvanshi, the then bellboy, came to the front office of the Rajmahal told Samendra Bose that the in charge of the front office, and he got a better job, and accordingly he would not come from the next day. Workman say Hitram Rajvanshi in his written evidence is proved by the facts stated in his written statement filed before this court. In his truth, he stated in the area that he did not keep any copy of his written attendance or the representation filed to the management of the hotel in 1/4/2001. Before this court, the management made a failed attempt to show that the worker had left hotel on his own volition. In the written statement filed by the management, it was stated that the workman attended different office of Hotel Rajmahal, informed that as he got better opportunity some other place, so he would not come to Hotel Rajmahal from the next day. On 2/8/99, notice was issued to the workman informing him that if he would not come by 16/8/19, his services would stand terminated. Having found the workman not attending his services by 16/8/99, a fresh notice was also issued to the workman, but this time also the workman did not respond. PWC Manoj Chetia stated in his evidence that he learned from the front office of the Hotel Rajmahal about the visit of workman Hitram Rajvanshi to the front office on 1/8/99 to express from the next day he would not come. PWC stated in evidence that Hitram Rajvanshi attended the front office.
Yes, I've gone through.
This is my lord, your lordship will come to the finding that is at page. May I take your lordship directly without taking much more time? The last one. At page 98. Second paragraph. Mr. O.P. Bhati, learned advocate for the management, has submitted before this court that the subsequent events have to be considered while passing a judgment by this court after filing of the case. Mr. Bhati refers a case reported in such and such. This case was with reference to Order 41 Rule 33 of the Civil Procedure Code. I have gone through the judgment, but the situation in our case is different from the situations in the case referred. Mr. Bhati, along with his prayer petitions, has submitted a few letters sent to the workers in the form of so-called notices, but all these intimations were subsequent to the award passed by this court on succession in this case, which was challenged before the Honorable Guwahati High Court by the management. Therefore, the said intimations do not bear any value in the eye of law, as because a competent court has already pronounced a decision on the disputed matter. From the foregoing discussions, it is true that Rivagman Hitesh Rajnishi did not leave Hotel Rajmahal on his own volition. He was deprived of his job and also from his due. His termination was illegal. That is the finding. Now, my lord, your lordship will come to the first order award. That your lordship will find at page 47. And the relevant operative part is at page 60.
Oh.
Para 60. Page 60, para 60. In view of the above discussion, I hold that the first term of reference is answered in negative. Holding the termination of workmen says Hitram Rajvanshi from Procedural by management of water is not justified there. And secondly, the second term of preference is answered in affirmative. Holding the workman is entitled to reinstatement with 30% of back wages and also full wages for the period from 1/8/99 to 24/8/99. Accordingly, the award is delivered on this day with direction to the manager of Hotel Rajmahal to reinstate the workman immediately and pay him back wages at the rate of 30% and also to pay full wages from the period from 1/8/99 to 4/8/99. That was the earlier order. Now your lordship has already seen the impugned order. There is nothing that such kind of benefits have to be given to the worker. Because this order has already been set aside by this honorable court. For this one, my lord, may I take your lordship the order dated at page 77 of this honorable court, my lord.
Yes.
My lord, I am taking the page 81 directly. In view of the inconsistent conclusion of the learned labor court, this court deems it appropriate that the ends of justice would be made if the matter is remanded back to the learned labor court for a fresh adjudication based upon the evidence which is already on record. It is provided the learned labor court shall take into consideration all the facts and material available on record and arrive at a conclusion as to whether the workman has left his job on his own volition or not. Accordingly, the award that is passed in reference case number is set aside. That order has been set aside regarding the payment of 30% back wages and the reinstatement from some particular thing. And there is no murmur at all so far the impugned order is concerned. It only says that it is illegal. So that again this matter requires to be referred for determination what amount I have to pay. And from which period I have to pay. Now, my lord, prior to earlier, when
Is
I
it
came,
necessary for you to challenge this labor court's order?
Yes,
It's the workman who has to challenge this the labor court
he has
order.
not challenged.
He is to challenge.
He is to challenge. Right. Even though, my
For
lord,
for what reason are you challenging this labor court order?
yes, that is so there, my lord.
No,
Because,
it is not a question
because,
of that is also there. That is the first hurdle you'll have to cross.
your lordship is absolute.
Hmm?
Because that order has nothing, no back payment has been, is to be paid.
See, the first award was set aside.
But even though, my lord, after that, what has happened in this particular case, that so far the earlier order is award is concerned, I came before this honorable. And this honorable court passed the interim order that your lordship will find at page 62. Page 62.
Hmm?
Page 62, my lord.
Hmm.
And relevant at page 63, my lord. Considering the matter, page 63, my lord. Considering the matter in its entirety and in its justice, it is well directed that until further order, the operation of impugned award that is the past case number 5, Parallel level of Guwahati shall remain stable to the extent that the state directs the petitioner to make payment of 30% of the wages and full wages of the respondent for the period from such to such. This order, this interim order was passed. After this order, my lord, what I did, I reinstated the workmen on 2/3/2010. This order was passed on 7/4/2010. I reinstated him even prior to it on 2/3/2010.
Hmm.
I reinstated him. That is a para 2, 3, and 4 of my petition, my lord. Your lordship will come. Sorry, my lord. I with effect to my lord service 1899. My lord.
Hmm?
He was reinstated from 2/3/2010, my lord. Page 83 and 84, my lord. Page 83 and 84. That is the petition I have given before the labor court, my lord. In this one, I have stated all the facts. My lord, para 3 thereof at page 84. The petition makes that pursuant to such direction, the workman or the opposite party was allowed to join on 2/3/2010. However, on 5/4/2000, the workman filed a leave application as prescribed by the management for leave on and from 7/4/2010 to 15/4/2010 on the ground of domestic problem. In between the period 2/3/10 and the leave granted, the workman was unauthorized absent on 25/3/2010 and such and such. Accordingly, management issued a notice. There is such and such to throw court against his unauthorized absence from his duty. Still no reply has been received. My lord, after reinstated and after that he did not attend. Still today he has not attended. And now the various notices have been issued to him, my lord, that your lordship will find that those were annexed, my lord. I have the copies of those documents, my lord. So, para 3,
Page.
page 84, my lord. May I read it, my lord? Entire.
Yeah, I'm on that.
Further, on expiry leave period, the workman was supposed to reply on duty on 6/4/2010. Still, he has not attended the duty. And in the meantime, 3 notices have already been issued to him under registered cover on substance, asking him to join his duty. By the notice that the substance, the workman was also asked to propose why the action should not be taken against him for unauthorized absence from his duty. However, the workman sent a reply dated 9/8/2010 that he could not attend his duty since 6/4 due to his illness, annexing therewith a medical certificate obtained from a private doctor. The manager, suspecting the correctness of this medical report, asked the workman by letter to submit all the medical description, the medical test reports, and apart from a report from the government hospital as to his fitness. Nothing has been done by the workman till filing of this application, and further since then, he has not attended his duty. The workman is,
The workman is now working?
I do not know, man. He, on each and every occasion, I issued the notice.
Is he now been reinstated?
No, I reinstated him.
No, that's why. After that, is he working?
Whether no, he took the leave from time to time.
No,
Those,
that's fine.
Huh.
Taking a leave, if it's entitled to the workman, that's a different thing. But then is he still working now?
no, still, if he comes tomorrow or today, tomorrow I am ready to keep him. But he remains absent.
You're working? No.
My lord, I am not allowed to join, my lord. That is the difficulties, my lord, despite the order passed by the
My lord,
Labour Court.
Okay.
If you are
They
lost,
have now, my lord, taken an hostile approach, my lord. They are not allowing me to enter into the, my lord, the hotel premises, Raj Mahal Hotel, which is situated in Paltan Bazar area, my lord. I was there for about, my lord, 15 years, from 1997 to, my lord, till my termination, which was illegally done by the operative commission. And thereafter, my lord, the labor court, my lord, proceeding was going on, my lord. And after hearing and on perusal of the materials on evidence on record, my lord, the learned labor court has come to the conclusion, my lord, your lordship has said, that he has been, my lord, illegally terminated by them. Thereafter, my lord, I tried, my lord, to join the service, but they did not allow us. Absolutely, my lord, hostile and arbitrary, my lord.
my lord, that is not the fact. Whatever he has submitted, he has not filed the affidavit, first of all. Secondly, my lord, I am throwing your lordship, whether he was allowed or not. And for that one, if your lordship will come to the record, because I have annexed all the documents, whatever I have received.
If not, file affidavit.
Yes.
I have not filed affidavit, but I have LCR is there, my lord.
So that will cover.
Okay. If necessary, my lord, I shall file a short affidavit, my lord.
No, I'm not, this court is not telling you whether to file an affidavit. or not. It's up to you. But it's in the hearing list now. It's in the hearing list. LCRs are here. Yes, Bhatti.
Yes, my lord. I am taking to your lordship to the application which I have filed before. Yes, my lord, the application from the record, my lord, which I have filed, that is on 2/03/2018 from record. 2/03/2018.
23.
2/03/2018, my lord.
to which page?
Page, my lord, I am directly taking your lordship to,
Of the records,
yes,
records.
the code, my lord, may I get it out? Because I have no paging.
Then we
So-
can't go like this. What you can do, whatever you are going to refer to,
Yes,
take the page number of these records. And then you make your arguments. Otherwise, handing over up and down,
Yes, it's
it
very
will make it difficult. By now, you should have known the page number in the records.
yes, my lord,
Lordship may do one thing, my lord, let the case be adjourned today. My lord, your lord, let my senior friend go through the LCR, my lord. Flag mark it, my lord. Then he will be, it will be very easier for the
yes.
civil court as well as the, my lord, the parties.
Yes.
Let it come on Tuesday, my lord.
Okay, I'll say on request made by the parties. List on,
And let it be kept as a part of my.
no, 18th.
But my lord, your lordship kindly, my lord, see, I have a small prayer. My lord. Your lordship kindly see the order dated 31st 3/2022, my lord. 31st 3/2022,
31st,
3/2022, passed by my lord, Honorable Justice Mr. Devashish Barua, my lord.
Mm. Have you complied with this order?
Yes, my lord.
No, my lord.
How I have
Today, my
complied? How I have come?
Thereafter, my lord, we have filed several representation before the authority to comply with the my lord, this the honorable court's order, but they have not paid it. They did not pay any heed to it. Till today, no compliance, nothing. How could he survive, my lord? He's a poor man, my lord, workman. And this, my lord, the law is very clear, my lord, 17B. Before filing this proceeding, my lord, he has to comply 17B. That has not been complied with till today, my lord, despite the order.
My
passed by
lord,
this
my lord, this matter may be taken up together on Tuesday, my lord.
Okay.
And I will satisfy your lordship that I have complied with. Since I allowed him to join, he did not come.
No, my
How
lord,
he can claim?
That is, my lord.
That I replied.
That is not correct proposition of fact, my lord. The fact is.
You filed the affidavit.
Okay.
Without filing the affidavit.
Well, I'll file an affidavit in the meantime. That may be allowed.
In the meantime, the respondent number 1 may file affidavit.
I'm deeply obliged.
My lord.
13 of supplementary list, motion.
My lord, there is a subsequent development.
Hmm.
We challenge the selection of my lord, the respondent number 7 as settlement holder. Now settlement has been made. I have been informed by my friend, and this order has been supplied to us. We have to challenge this also, my lord. So, my lord, I may be allowed to withdraw with the liberty to refile.
Okay. Mr.
And how?
Learned counsel for the petitioner, prays for withdrawal of this petition. With liberty to file afresh.
Right.
Stop. Mr. P. Sharma, learned standing counsel,
AFTC.
appears for the AFTC. And how many respondents are there?
I could respond to 3, 5, and 6 year old.
4%. He's also there.
And MS, SC, ST, learned standing counsel, cooperative department. For the respondents, 3, 5, and 6.
So, what else?
And MS, you does, then government advocate for the
Respondent
respondent.
number 7, lordship.
And MS
R Kapote.
R Kakuti for the respondent number 7. Huh? Stop.
And for 1 and 2.
Writ petition is dismissed on withdrawal with liberty aspect.
Okay. Right.
Oh, hi. And where the respondents counsel?
You know, the password for the day.
You want it passed over for the day. But how many unlisted matters are there? Oh, it does not come. Okay. Okay.
Item 11. Government road. SDIS. LCD, Mr. LCD, Mr. HD. Government road. Union of India against.
Union of
There's a private respondent also.
Yes, Your Honor. Check once. Yes, Sri Vinod Chandras Burman.
item 11.
I think your senior is joining through VC.
My lords will kindly keep it at 2 o'clock, my lords. I am just joining. I have some connectivity issues, my lord, and my video is not operating. Will my lords be kind enough to keep it for 2?
That's not an issue. The only thing is that I don't see any respondents council. This is the issue.
Yes,
Anyway,
my lord.
None of the respondents are represented today.
Lordship pleases.
And
Lordship.
whatever it is, okay, we can take up at 2. Let us see if your junior can catch all of the respondents council.
My lord, I'll ask my instructing counsel to switch out to the other side.
Okay, okay.
I'm deeply obliged.
At 2, we'll take up.
Item 11.
May it please, my lord. My lord, I am told that the other side is also here. We had passed on the message and they are here.
He's the. Yeah, for the respondent?
Respondent number 3, ma'am.
3. And what about 1 and 2? Union?
Respondent number 2 is only a performer respondent in that sense, and even Union of India.
2 is not a party. They are not required to be here.
Not
But how
required.
about 1?
Who is presiding officer?
At least
Is it-
one should be there. Union,
Union of India.
they have the CGC, isn't that?
CGFC.
Yes, yes, my lord.
Could you contact them?
Yes. No, I told them, but they are not here now. I'll just send them.
Just check up.
Probably the reason why they are not repairing is because actually it's a dispute between the petitioner and the respondent number 3. So they would have ideally thought that they are not a necessary party in that sense, to the dispute at least. Though of course, otherwise they are a party. Manoj, if I could, in the meantime, just give a background of the matter.
Yes, please.
This writ petition, my lords, challenges the judgment of the Labour Court, by which the Labour Court, my lord, says that this respondent number 3 was retrenched without following the process of 25F of the Industrial Disputes Act. Our case, my lord, is that 25F is not applicable because he was a person who was engaged on a contractual basis, and my lords, his contract was not renewed. Hence, my lords, he does not fall within the definition of retrenchment. Now, if my lords could see section 25F for a moment, and then, my lords, I will show my lords the definition of retrenchment. Kindly, my lords, turn to section 25F.
Parasar, you in this matter?
My lord has section 25F.
Yes, please.
May I read, my lord? My lords will kindly note the heading. It says condition precedent to retrenchment. My lords will note of workman. So the two operative words in this particular section are, my lords, one is retrenchment and the second is workman. I'll make good the case when I refer to the definitions of both these two terms, my lord. It says no workman employed in an industry who has been in continuous service for not less than 1 year under an employer shall be retrenched by that employer until, my lords, these conditions are mentioned and these conditions have to be fulfilled. So the most important would be, my lords, one is the 1 month notice which is given. Then, my lords, the compensation at B, my lord. And C, my lords, where a state government issues a certain notification saying that the notice has to be in a prescribed manner. That is what is provided for in C. So these are conditions which are required to be fulfilled before a workman is retrenched. Now, the operative words, my lords, will kindly note, one is retrenchment. Now, if I could draw my lord's attention to the definition of retrenchment, because the reason I'll also place before I read the definition, according to us, my lords, if non-renewal of a contract is there, then it is specifically excluded from the retrenchment definition. Kindly come to, my lord, section 200. Section 200, my lord. The definition of retrenchment.
Yes.
My lord has it. May I read, my lord? The retrenchment means the termination by the employer of the services of a workman for any reason whatsoever, otherwise than as a punishment inflicted by way of disciplinary action. My lords will please note these words now, but does not include, I am relying on double B, my lord. The exception at double B, termination of the service of the workman as a result of non-renewal of the contract of employment between the employer and the workman concerned on its expiry of such contract being terminated under a stipulation in that behalf contained therein. So one of the exceptions to the rule of retrenchment is the termination of service based on non-renewal of a contract. There's a Supreme Court judgment, my lords, which explains 25F, but I wanted my lords to independently also see the provision and satisfy my lords what are the conditions which are required to be fulfilled in order for a person to be given the benefit of 25F. The most important being, my lords, he has to fall within the definition of retrenchment. In my respectful submission, my lord, if it is a contractual employee and the contract is not renewed, he does not fall within the purview of retrenchment. And in my case, on the facts, I will demonstrate to my lords that he was in fact a person who was appointed, or rather he was engaged on a contractual basis based on contract which is accepted. And then subsequently, my lords, after a period of time, his contract was not renewed and then he goes to the Labour Court. So this is the definition, my lords, as far as retrenchment is concerned, which specifically excludes from its purview those employments which are contractual in nature. Now, my lords will kindly see what is the definition of workman, whether he falls under the definition of workman, my lord. Please come to, my lords, 2S. S for sugar, my lords.
Yes.
My lord, may I read that? Workman means any person, including an apprentice, employed in any industry to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or for reward, whether the terms of employment may be expressed or implied. And, my lords, please note this part. For the purposes of any proceedings, which will be also under 25, under this act, in relation to an industrial dispute, includes any such person who has been dismissed, discharged, or retrenched in connection with or as a consequence of that dispute. So the words used, my lords, are a person who has been retrenched. So a workman, my lords, for the purposes of any proceedings, it has to fulfill the definition of the word retrenched in my respectful submission, because it says, my lord, may I just read it again, for the purposes of any proceedings under this act in relation to any industrial dispute, because he has, my lords, come under the Industrial Disputes Act before the Labour Court, saying that, my lords, this is a industrial dispute. Hence, he has to fulfill includes any such person who has been dismissed, discharged, or retrenched in connection with or as a consequence of that dispute. Or, my lords, will kindly see, or whose dismissal, discharge, or retrenchment has led to that dispute. So, in my respectful submission, he also does not fulfill the definition of the word workman in an industrial dispute setup under the provisions of the Industrial Disputes Act, because it presupposes that that person has to be retrenched. And as I have demonstrated or tried to show to my lords, that retrenchment as a definition or as a concept which is provided for in the Industrial Dispute Act excludes from its purview, my lord, non-renewal of a contract if it's a contract of employment, that is specifically excluded from the purview of retrenchment. Now, my lords, will kindly see in the facts of the case, my lord, may I just place for my lord's consideration one judgment which squarely, my lords, says what I have just submitted to my lords, or the point that I'm trying to make good to my lords. One judgment squarely on this point, my lords. My learned friend will hand over a compilation of judgments which we have prepared for my lords. And my lords, before that, if I could just point out what is the status of this particular person, which is respondent number 3, my lords, will kindly see his the engagement contract, that is, my lords, at page 102 of the writ petition. Just to give a factual background as to how the dispute has emanated and come before my lords today. Kindly see 102, my lord. Page 102 of the writ petition.
Yes.
My lord has that. This is, my lords, the contract dated 28th of September 1998, by which we, my lords, engaged the services of this gentleman as a peon on a contract basis from, my lords, will please note the period also is noted, 6th of October 1998 to 5th of January 1999. And my lords, will kindly see the terms. It clearly says that serial number 3, my lords, may I read that? Your association with this authority in connection with the above activity in no way will constitute an employer-employee relationship, and as such, this authority shall be liable only to make payments for the services rendered. So very clearly, the contract clearly says that there will be no employer-employee relationship, and we will not be liable for anything else besides the payment of the money for the services rendered by you under the contract. And my lord, serial number 4 says it will automatically terminate without making any reference to you. And then most importantly, my lords, the person has, the respondent number 3 has also signed and accepted, my lords. That is, of course, this is a typed version. My lords will see his endorsement at page 103, which is the actual copy. It's a little illegible. That's why we placed a typed copy. But my lords will see his endorsement and signature at page 103, bottom of the page. My lord has seen that?
Yes.
Yes. Now, my lords, will kindly see my lords, over a certain periods of time, he was, my lords, engaged. And finally, there was one engagement, which is at page 104. Page 104, it's a G. This is the contract dated 8th of July 2011, my lord. And this contract again.
The first was?
First was 1998. My lord, kindly sees the date. 28th of September 1998.
Okay.
This, my lord, what I'm pointing to, my lords, at page 104 is dated 8th of July 2011 at page 104. And this contract, my lords, for again a specific period, which will be evident to my lords if my lord sees the first terms and condition, the serial number 1, it says from 8th of July 2011 to 31st of December 2011. Then again, serial number 3 says engagement of services of this contract shall not create any right or relation of employer-employee. Now, my lords, will kindly see the determination. Please see serial number 4. The contract shall not bestow any right to so-and-so for claiming regular employment in this authority. Now, 6. The contract is terminable at any time during the period of the contract by the authority without any notice to that effect and without any reasons to be stated by the authority to the persons on contract, and as such the authority has full rights to cancel at any time during the period of the contract. Now, what is also important, my lord, is serial number 8 and 9. The contract shall stand rescinded automatically at the last date of the contract. So this is very clear. And also, my lord, this is not an unfair contract, because serial number 9 says that the respondent number 3 is also at liberty to terminate. So therefore, contract is very clear that either I can terminate or you can terminate, or otherwise the contract shall stand terminated with efflux of time on the date on which the contract expires. And then, my lords, serial number 10 also, during and after the contract, it will not confer any right to so-and-so for any claim or rights for any benefits which are normally available to regular employees of the authority. So very clearly, the contract also specifies that you cannot claim any special right of a regular employee. You are only a contractual employee, hence you are only entitled to the money under the contract for the stipulated period of time that you are contracted for. And my lords, will kindly see at the bottom of the page, he has also signed. The reason why I'm harping on the point of signatures, my lords, is also because there is a Supreme Court judgment that says that when you have accepted the terms of a contract, you cannot suddenly claim to be an employee or a regular workman and then claim your rights under the Industrial Disputes Act. Hence, I'm pointing out, my lords, all the documents where he has accepted the terms. That signature, my lords, and the handwritten acceptance is at page 105, because the actual letter is at 104B, and at page 105, bottom of the page, my lords, will see the endorsement of his acceptance. Now, my lords, in this light, now then he goes, my lords, to the labor court, and let us see, my lords, the judgment of the labor court first. If I could turn my lords' attention to annexure B at page 39, which is the impugned judgment before my lords. Annexure B, my lord, page 39. It starts.
According to you, this his contract appointment,
yes, my lord,
expired after 31/12/2011.
Yes, my lord.
He was never appointed thereafter.
He was not appointed, and I will show now from his claim statement that this is also his averment. His averment is, yes, if I could just show that averment directly, my lords, since my lords have put the question to me, I'll answer it immediately. Kindly see his claim statement, my lords, at page 132. His claim statement actually starts at page this is, my lords, at page 128.
128?
It starts 8, my lord. 128, my lord.
Yes.
And kindly come to the averment. What is his case before the labor court, my lord? Is at page 132, my lord. 132, my lord.
$132,
my lord. Actually, my lords can have 133, which is the specific averment. I don't want to trouble my lords to go through the entire petition. 133 directly, one paragraph itself, para 8, top of the page, my lord. If I could read that, my lord. That the claimant in the aforesaid manner worked as temporary employee, my lords, will please note. Actually, he's not a temporary employee, he's a contractual employee, and so this is the authority. Up to 31st of December 2011, and thereafter the services of the claimant was terminated without any notice. Please note this, that his grievance is that he has worked till 31st of December 2011, which answers my lord's question that my lord put to me, His case is that he has worked till 31st of December 2011, but he was terminated without notice. Hence, my lords, 25F. That is his grievance. Notwithstanding our case, my lord, that he's not a temporary employee, he's a contractual employee, hence not coming within the purview of 25F. Now, if I could read further, my lord, para 9. That the claimant thereafter submitted a representation dated so-and-so before the management to allow the claimant to continue in the service. The claimant was not allowed in service since 1/1/2012. So this makes good the case as to what was his case before the Labour Court. Now, my lords, will kindly see para 11 is most important because that actually calls the bluff of the respondent number 3. Please see para 11, my lord.
Yes.
The management thereafter, vide its letter dated so-and-so, informed the authority that the service of the claimant was not extended beyond so-and-so due to negligence. Whereas he is using something else, but the fact remains that his case was, he is now, my lord, alleging several other things which I will point out later, but the fact remains that his stated case, his pleaded case before the Labour Court was that his services were not renewed beyond 31st of December 2011. But that is his pleaded case before the Labour Court. And before, I could also show to my lords what in the written statement what point I have taken, so that my lords are very clear. I am very clear to my lords that we have not raised a new point. I have raised the point of retrenchment in my written statement, my lords. That starts at page 174. I'll satisfy my lord also on that. Page 174 is my written statement. And my averment, my lords, categorical averment at page 175, second paragraph. If my lords could see page 175, second paragraph, my lord.
Yes.
175, my lord. Second paragraph, may I read, my lord? That admittedly the claimant was engaged in contractual basis from time to time for fixed period and on fixed terms and condition. His last contractual period ended on 31st of December 2011, and thereafter the management is not extended into a fresh contract with the claimant. Now, my lords, will kindly see page 176, second line from the top, my lord, page over at page 176.
Yes.
Of the page, second line, my lord. However, after December 31st of December 2011, it was decided that as the workman has gone down, no such contractual employee is necessary, and in fact, till now, 2 officers are running. So, my lords, because we did not need the staff, hence, my lord, his contract was not renewed. So, we have given the reason also why the contract was not renewed. Now, on the specific point of retrenchment, that is 200, my lords, we have said so. My lords, will come to page 178. 178, my lord. Bottom of the page, my lord, last paragraph. As defined under section 200, non-renewal of contract of the engagement is excluded from the definition of retrenchment, and as such, the question of fulfilling the condition precedent under section 25F does not come. So this was my case and my defense before the Labour Court to apprise my lord and to show my lords that I have actually taken this point before the Labour Court as well. Now, how does the Labour Court deal with the case, my lords, will be evident from the impugned judgment, my lords. If my lords, I could trouble my lords to come back to my lords, page 39, annexure B, and the judgment starts, my lords, at 39B. B for Bravo. 39B, my lord.
Yes.
And my lords will kindly come to directly come to my lords, page 39B, D for Delta. And bottom of the page at 39D, my lord, last 3 lines are what I'm referring to. This is in his cross-examination. He further admitted that after 31st of December 2011, His services were not extended. He also admitted that no interview took place during his selection. He stated that he did not know the management file so and so. So it is an admitted position, my lords, that this was not an advertised post. In fact, my lords, I will also show to my lords that in the regional office of the petitioner before my lords, there is no post that exists. So, my lords, the point is like this, that the labor court says you please reinstate. I will also show judgment of the Supreme Court, my lord. What is the actual definition of reinstatement? Reinstatement implies that you have to put the workman back into his original position to the original post, my lord. There was no post to begin with, so there effectively cannot be any reinstatement. But before that, my lords, if I could just show to my lords the submissions which were made at page 39F, para 7. The submission of the workman at para 7, 39F. Because the workman says that, my lords, third line, it says there clearly existed a relationship of employer-employee between the management and the concerned workman. In view of the admitted facts, according to the council, termination, retrenchment of the concerned workman ought to have been dealt with in accordance with the provisions mentioned in section 25F of the Act. So this is the case, my lords. And continuing on page 39G, where it says that the termination is illegal, and he should be reinstated with full back wages, which is mentioned at the top of the page. Next page, my lord. Because I am not going on the point of misconduct, my lords. There was an additional point of misconduct which we had pleaded before the labor court. But my lords, because no substantial evidence was led and we were not able to prove that, my lords. So I'm not even troubling my lords on that. I'm only on a legal point today before my lords, whether it constitutes retrenchment and hence the benefit of 25F. Then, my lords, will kindly see at page 39G, para 8 are my submissions. My lords have already seen that. I don't want to trouble my lords, para 8, because I have shown my lords my written statement where I have taken the same point, my lord. And we have said that it is on a contractual basis. Now, my lords, will kindly see the discussion at para 9. It is important, my lords. May I read para 9? On perusal of the material on record, it appears that the engagement of the workman on the basis of contract agreement for more than 13 years for certain breaks is not in dispute. Admittedly, his engagement was discontinued from 1/1/2012. In other words, the primary facts are not in dispute. It is clear from the material on record that from so-and-so, the workman was clearly working as a peon in the office of the petitioner with certain breaks. His wages were directly paid by the management. His original appointment was given by the head office of so-and-so. And as well, please note, accordingly, there appeared a clear employer-employee relationship between the management and the concerned worker. Now, my lords, will kindly see para 11. Then at para 10, if I could tell my lords that the conduct about the misconduct is noted at para 10. I'm not troubling my lords to go into that because that is not something that I'm going to dwell on. So para 11, if my lords could kindly see the next page. May I read para 11?
Yes.
In view of the facts and circumstances of the circumstances as discussed in the preceding paragraphs, it appears to me that, my lord, this is important, that though technically engagement of the concerned worker was in terms of exhibit number so-and-so, these are the contracts, the sheer length of his continuity, 13 years in the job, is bound to lead to a natural inference that he is an employee of Veda, though to lead to a natural inference that he is an employee, though not a regular one. Please note the words the regular one, my lord. I'll point out. Admittedly, he is not a regular employee, but materials on record clearly suggest that the nature of work done by him perennial in nature. The workman has worked for 13 years in APEDA. Hence, the action of the management of APEDA, which is a unit of government, without adhering to the provisions laid down in section 25 of the Act, is illegal and arbitrary. And para 12 says he is to be reinstated. And, my lords, he is to be paid a lump sum amount of 1 lakh as back wages. Now, the finding categorically of the labor court is at para 11, which, my lords, clearly in my respectful submission, actually says that he is not a regular employee. So, if it is the finding of the labor court that he is not a regular employee, then, my lords, under the Industrial Disputes Act, this is not even a case. Because in order for somebody to fall within the purview in my respectful submission of an industrial disputes and retrenchment, there has to be a regular employment. I will make good my case by the judgments which I will show to my lords. which clearly says that unless and until the condition precedence of section 25F, which one is employer-employee relationship, second, my lords, and most importantly, that he has been appointed to a regular post. Irregular appointment or illegal appointment, my lords, does not fall within the purview of section 25F. If I could, my lords, draw my lords' attention based on the finding, if I could now turn my lords' attention to the compilation of judgments which I have prepared on the legal point to demonstrate, my lords, that the entire foundation of the case of respondent number 3 is that he is a temporary employee. If he is a temporary employee, my lords, then he has to show as to how he falls within the purview of section 25 Act, merely because, my lord, there is a judgment also which says that even though a person has worked for a long time, but under a contract, even though renewed over a period of time, and it is not a regular employee, he cannot take the benefit of 25 Act. Now, if I could, my lords, trouble my lords to come to the compilation of judgments, the first judgment being, my lord, has the compilation, has my colleague handed over the compilation. If I could draw my lord's attention to the first judgment, which is, my lords, Surendranagar District Panchayat versus Dhayabhai, which is reported in 2005, volume 8 SCC 750, and that starts, my lord, at page 1 of the compilation, my lord.
Oh.
And without troubling my lords to go through the entire judgment, I will just take my lords to page 7, which discusses section 25F and section 200. Page 7, my lord. Top of the page, placitum A, my lord.
Yes.
May I read this, my lord? Retrenchment is defined in clause 00 of section 2 of the Industrial Disputes Act 1947, hereinafter referred to as the Act. Under the definition, termination of service of a workman by an employer for any reason whatsoever other than as punishment by way of disciplinary action would constitute retrenchment, except in cases accepted in the section itself. They are a voluntary retirement of a workman, 2, retirement of a workman on reaching the age of superannuation, and 3, my lords will note, termination of the services of a workman as a result of non-renewal of contract of employment, and 4 is termination on the ground of ill health. I am relying on small Roman 3. Now, my lords will please see these. Unless these reasons are shown to have existed and proved, the termination of an employer, termination by the employer of the services of a workman for any reasons would constitute retrenchment. Therefore, if an employer is to retrench the workman employed in his industry who has been in continuous service, he has to follow the provisions of section 25F. Now, let us please see the next part. To attract the provisions of section 25F, the workman claiming protection under it has to prove that there exists a relationship of employer-employee, that he is a workman within the meaning of section 2S. The establishment is in which he has been employed is an industry within the meaning of the Act. He must have put in not less than 1 year of continuous service as defined by section 25B under the employer. These, now this is important, these conditions are cumulative. If any one of these conditions is missing, the provisions of section 25 Act will not be attractive. To get the relief from the court, the workman has to establish that he had the right to continue in service and that his services was terminated without complying with the provisions of section 25F of the Act. So this judgment clearly sets out, my lord, that it is for the workman to show that he does not, my lords, fall under the exceptions, 1. Second, he has to show that there is an employer-employee relationship. Then, my lords, he has to show that he has worked for 1 year in a continuous service. And, my lords, most importantly, then he has to show that he is a workman. That he is a workman within the definition of section 2S. So, if he is not a workman, then these condition precedents being cumulative in nature, my lord, as the judgment succinctly points out, he is not entitled to the benefit of 25F. Now, my lords, the second judgment regarding the length of service, which I was trying to point out that is not a criteria, is in the second judgment, which is Kishore Chandra Samal versus Orissa State Cashew Development Corporation. At page 12, it starts. This is a judgment reported in 2006, 1 SCC 253. And my lords will kindly come to the facts of the case, which are important. At page 13, para 3, my lord. If I could just trouble my lords with the facts of this case, because this is a similar case and I want to lay emphasis on the facts, then come to the conclusion. Para 3, if my lords could see, the respondent case before the Labour Court was that the appellant was working on a NMR, means my lords nominal master role, as a typist with effect from 12th of July 1982. He was appointed for a specific period on daily wage basis on consideration of the representation for regular engagement, and having regard to the requirement, he was again, my lords, please note this, he was engaged again and again on daily wage basis for a specified period, exactly like our case. The last order of appointment on NMR basis was issued to him on 20th of April 1989. Thereafter, no extension was given. Thereafter, his services were automatically seized, and it is not a case for retrenchment. So, very similar to my case, very similar to my case, where his case was also that his engagement was extended from time to time and then subsequently not renewed, which is exactly the fact situation in this case. Now, coming to para 4, what does the Labour Court find in the facts of that case, my lord? The Labour Court, on perusal of the evidence on record, held that the appellant served continuously for many years, covering the requisite period of continuous service in the calendar year. Although there is no evidence that the post of typist is a permanent one, he is engaged from time to time, and the time of termination, as the provisions of Section 25 Act had not been complied with, the termination of service is illegal and unjustified. On the basis of the said finding, the Labour Court directed the appellant to be reinstated in his former post. Exactly the same thing has happened in our case also. Now, my lords, kindly see what the High Court do. The High Court accepted the stand of the respondent corporation that the appointment of the petitioner appellant herein was on NMR basis for a fixed period of time on the basis of payment at different rates. The contractual period of engagement ended on 3/5/1989 and there was no renewal thereafter. Since the engagement was for a fixed period, the High Court held that the award of the Labour Court was to be set aside. Now, this is at para 6, my lords, they rely on a judgment which has been relied on by the respondent number 3 also. My lords will kindly see para 7. The position of, my lords, section 200BB is, my lords, noted at para 7, which I've already placed before my lords. I don't want to trouble my lords on that. Then my lords will directly come to para 11 at the next page, my.
Yes.
Para 11, the decision in so-and-so has no application because in that case, no period was indicated and only indication was temporary nature of engagement. In the instant case, in all orders of engagement, specific periods have been mentioned. Therefore, the High Court's order does not suffer from any infirmity. Precisely this case, my lord, where in every appointment letter, and this is an admitted position, it was for a specified period of time, and the last employment was on 31st of December 2011, my lords. The period ends, and exactly in the facts of this case also, which I'm reading to my lords from the reporter, exactly the same fact scenario where his contract ended, and my lords, the relationship comes to an end. The High Court found that there is no, it does not make out a case for 25F, and the Supreme Court has reaffirmed that at para 11. Now, my lords, will kindly come to what is reinstatement, which is the third judgment in the compilation, my lord. That starts at page 16. And my lords, the definition or the discussion on what is the scope of reinstatement is at page 36, para 21 of the report. Para 36, page 36 of the compilation, where the Supreme Court discusses what is reinstatement. This is also important because I will show that there is no post for reinstatement. Para 21, my lord, has?
Yes.
If I could just quickly read that, my lord. The word reinstatement has not been defined in the Act. Now, this is the Industrial Disputes Act and the rules. As per Shorter Oxford English Dictionary, volume 2, so-and-so, the word reinstate means to reinstall or re-establish a person or thing in a place, station, condition, etc., to restore its proper or original state, to reinstate afresh. And the word reinstatement means action of reinstating, re-establishment. As per law lexicon second edition, the word reinstate means reinstall, reestablish, to place again in former state, condition or office, to restore to a state position from which the object had been removed. And the word reinstatement means establishing to a former condition. So this clearly sets out, my lord, that in order for me to reinstate, I have to reinstate him back to the position of a peon. Now, in the authority today, or even at that particular relevant point of time, there was no post of peon. And in fact, my lords, in 2011, I'm sorry, my lord.
Till today, there's no post.
There is no post. Even, in fact, after 2011, my lord, this particular post of peon has been abolished. And now, my lords, my lords are aware, multitasking staff, MTS, my lords, rules have come into place in all departments of the Union of India, as well as the, my lords, the states, where they are called multitasking staff. And, my lords, there is no scope for a post in the regional office. My lords will kindly see that in the regional office, I've placed, my lords, we have placed the entire set of posts in this particular authority all over the country. My lords, that is starting from page 94 onwards, my lord. Page 94. And my lords will directly come to the posts, which are at page, it says annexure, page number, my lords, will be 98 onwards, my lord. My lord sees on top at page 98, restructuring in terms of number of posts. I'm sorry, page 98, my lord.
Yes.
So these are the posts which are available. And it shows what posts are sanctioned, what are abolished. Continuing there, my lords, will come directly to, this is a regional office. So we are governed at page 100, my lord.
100?
100, 100, my lord, 100. This is a regional office. Admittedly, this is a regional office. Now, my lords will kindly see the name of the posts are mentioned in the, my lords, the second column. And my lords, if my lords moves a few column to the seventh column, it says Guwahati. It says on top, it says regional offices. And there, my lords, several cities are mentioned. And the fifth column there, my lords will note is Guwahati. My lord has that. So now my lords will correlate it with the post at in the second column. It says assistant general manager 1 post, assistant manager 1 post. And the total number of posts is only 2.
Okay.
There is no post, my lord, pertaining to any MTS. Even at the relevant point of time, my lords, there was no post because this is only a regional office. That's why he was, my lords, engaged on a contractual basis. There is no other reason why. This is the only reason. At the relevant point of time also, between, my lords, 1998 and 2011, the post did not exist. So if today I was to, my lords, told to comply with the directions of the labor court, I cannot reinstate him because there is no post. And my lords, if my lords had seen, as I pointed out in the labor court, his specific, my lords, acceptance in the cross-examination is yes, he was not appointed pursuant to any advertisement. There was no interview, and the post was only a contractual post, my lord. So if it is a contractual post, there is no question of bringing in the concept of section 25 because there is no re-entrenchment. Hence, he is not entitled to the benefit, in my respectful submission, of the, my lords, of the benefit of the Industrial Dispute Act, section 25F. Now, if I could just point out just one last judgment which is in the compilation, which is very similar to, my lords, our case. That is why I have placed the Gujarat High Court judgment, my lords. That is at page 52 of the compilation. It starts. This is Rasmila Ben Thakkar versus Indexed Industrial Extension Cottage at page 52, my lord. My lord will kindly see the facts of the case at page, my lord, 57. And here also, my lord, the person had worked for a period of 5 years. And para 4.2, my lord, is the case of the respondent, which is not the workman, but for the employer. She further submitted that the Learned Labour Court has specifically found that the present petitioner is appointed as a Gujarati stenotypist on so-and-so on contract basis for 1 year on fixed salary of so-and-so. She further submitted that as per the consent letter produced at exhibit so-and-so, the petitioner workman had agreed. This was I have to point out, my lords, what was the emphasis being laid, my lords, to the terms and conditions. This is where I was coming at, my lord. She further submitted that the document which is produced as exhibit 20, more particularly para 7, clearly indicates the workman has to render service as per the duties given to him by the institute in a reasonable and satisfactory manner. Now, my lords, para 4.3. She further submitted that if we were to read Section 200BB of the Industrial Disputes Act, the definition of retrenchment clearly indicates that if the services rendered by the employee workman is terminated as per the conditions of the contract, then it cannot be considered as retrenchment, and therefore she is categorically submitted that the appointment is made on so-and-so as per document for a year. Thereafter on so-and-so, the services of the present petitioner automatically comes to an end. Now, my lords, will come to page 61. The findings, my lords, start at page 60 onwards. Para 5.2. Kindly see that at page 60. I found that the Learned Labour Court has given detailed reasons while recording findings. In the impugned judgment and award passed by the Learned Labour Court, it is also pertinent to note that as per the letter produced as Exhibit 20, the petitioner is appointed on 1 year fixed salary per month with a letter dated so-and-so, and therefore such appointment is made for a period of 1 year. It is contractual, and the signatures which is put on document Exhibit 20 by the present petitioner is not disputed by the petitioner workman. It is also found from the record that the signature of the consent is proved. Well, this is not in dispute, my lord, so I am skipping that. Therefore, when the petitioner has accepted the terms for employment on contract basis, then now she cannot agitate that the respondent institution had to consider her continuation of service on the basis of the document which is executed for the purposes of contractual employment. Now, my lords, will kindly see at the bottom of the page, about 6 lines from the bottom, it further transpires from the record that there was no advertisement published in the newspaper before appointment made to the petitioner in the year 1994, and the appointment order given to the petitioner in 1994 was for 1 year, which is coming out from the pleadings and cross-examination of the present petitioner before the Learned Labour Court. So, therefore, my lord, the court goes on to hold at page 66. 66, 67, the court says that there is no infirmity in the Labour Court's findings. Para 5.4 has not committed any error, as the petitioner working is not entitled to get any relief as prayed for. So similar in this case also, my lords, the petitioner in this case, my lords, had continuously worked for a period of 5 years. That is evident from, I will also satisfy my lords on that. I had found that point also, my lord. Yes, page 55, my lord. Page 55, top of the page. But period of 5 years. So here also 5 years. And the Supreme Court judgment also, which I pointed out earlier, my lords, it does not matter what is the length of service. That is immaterial in my respectful submission for the consideration. If it is proved that he is not a regular employee, and the Labour Court in this case, in my case, also finds that he is not a regular employee. My lords, the categorical finding is that not a regular employee. So if he is not a regular employee, then in my respectful submission, my lords, he does not fall within the purview of the Industrial Disputes Act at all. So
in the present case,
my lord,
how many years he has put in as a contractual employee?
My lords, if my lords, our case is that he has worked between the period, the first, my lords, if my lords had seen, the first contract is of 1998 and the last is of 2011. So between that period, our case is that he was engaged whenever he was required from time to time for certain specific periods of time, which were mentioned in every contractual, in every contract that he was provided. The length of the period was also mentioned. 6 months period he was engaged. The first one and the last one I have shown. Unfortunately, I don't have all of them. It may be there in the labor court record, which may be before my lord. Unfortunately, I will not be able to assist my lords about the interregnum. How many of them came in? I am sorry, my lords, I will not be able to point out. But let us take it. I'm assuming the worst against me that he has been regularly engaged from 1998 to 2011. I'm taking the worst against me, because that is what the labor court also finds against me. The only reason why the labor court says that you have to be reinstated is that, my lords, he has worked for a length of 13 years is what the labor court says. So this is the only sole criteria or the basis of the foundation of the labor court granting, my lords, relief to the respondent number 3. Otherwise, the finding is in my favor that he is not a regular employee. So my respectful submission, my lord, is that he does not fall within the definition of retrenchment, falling within the exception of a contractual employee. Hence, in my respectful submission, not entitled to the benefit of 25F. My lords, the only thing that he can claim in a civil court, my lord, is that he was wrongly terminated. In a civil suit scenario, maybe he may be entitled to show that I've worked for this period of time and I have been wrongfully terminated without a notice, my lords. Same on the principles of natural justice, if he can point out. In a civil court, he can ask for compensation, but not reinstatement under the Industrial Disputes Act. And especially in view of the fact, my lord, that there is no post today, as I've shown to my lords of a peon, I cannot reinstate him. It is not possible. So that order itself, my lords, cannot be complied with. So the labor court has also erred on that, because we had also pointed out before the labor court that such a post does not exist. So despite that, my lords, the labor court finds that he is entitled for reinstatement. So my respectful submission is that, my lord, the labor court order may be set aside, my lord, and he has the right to claim compensation in a civil court. That remedy is always available to him. I am deeply obliged.
Yes.
My lord, my learned advocate for the petitioner side has raised some point regarding workman and labor worker relationship. In this regard, my lord, the matter has already been decided by the tribunal in courts of trial, taking the matter as a preliminary issue, whether FPTA is an industry and is there any relationship between the workman, that is respondent number 3, and the management as workman management relation. So this matter has already been decided as per order of this honorable court. Initially, they took the plea before this honorable court. The honorable court remanded the matter to the CGIT with direction to decide whether the FPTA is industry or not. In this connection, learned presiding officer CGIT, in his order dated 3/11/2017, my lord, page 365 to 371 of my affidavit in opposition.
Of your
Affidavit in opposition.
page?
Page 365 to 371.
365.
365 to 371, my lord. Annexer PRP.
No. Your affidavit in opposition. Your affidavit in opposition starts from page
Affidavit
255.
starts from my lord to 296, man.
I don't have 296 here.
Anyway,
32.
in my affidavit in opposition also I am submitted.
No, your affidavit in opposition is there.
Yeah.
There's no doubt. Page 32. Yes. So the labor code held that the ABDA is a industry.
Industry.
So there's no issue on that. Isn't it? In
Yes,
this
sir.
writ petition.
They took the plea
Hmm.
that it is not industry and respondent number 2 is not entitled to any relief in this proceeding.
They are not addressing to that issue.
Yes, right.
What they are trying to address is that you're not a regular employee of the ABDA, and therefore section 25F does not come into play in terms of the definition 200.
My lord, he was appointed by their head office at Delhi
Hmm.
by direct recruitment process, and appointment letter was also issued.
There was a
Appointment was
there
on
was a
contract basis.
there was a recruitment process.
Yes, my lord, they have already invited his application and he issued with the appointment letter.
Come to the findings of the labor court. Labor court said there was no recruitment process.
No, there is no procedural recruitment, but he was appointed. and
Okay,
the
leave
appointment
that
letter
aside.
was
Leave that
issued.
aside
Yes.
also. Now, are you a regular employee or are you a contractual employee?
Contractual, my lord, but he worked continuously for 13 years, 3 months.
Correct.
And although they took the plea that periodically he was appointed, but without any break, continuously worked 240 days in each and every year.
That's fine.
So they
Have you given him a copy of your compilation?
A compilation I have not, I'll supply.
Well,
How
I'm
do you
sure
how do you overcome these judgments?
my learned friend is handing over.
Compilation. আমি rely করি। That's it.
So, my lords, my learned friend ought to have given it. I was not aware, my lords. I didn't.
Yeah.
I'm so sorry, my lord.
Have you gone through these judgments?
No, my lord, these are not supplied to us.
Okay. Okay. Now he has supplied. Doesn't matter. How do you overcome these judgments?
Sometime may kindly be allowed.
How?
I got so many judgments.
You were not listening. I'm keeping it parted.
My lords, since my
Yes,
lords have, my lords, these are judgments that my learned friend can distinguish, or if at all, my lords. Normally, my lords, we do it over a course of the arguments, my lords. There's no specific time, my lords, since my lords have already heard the matter
Yes.
substantially. I leave it to my lords. Whatever my lord pleases, I leave it.
2 days, no, 3 days time may kindly be allowed.
Okay, let us give them some time.
Fine.
Because the copy was served only now.
Yes, ma'am.
Maybe heard Mr. CP Sharma. Correct. Learned Senior Counsel, assisted by Mr.
K.R. Borua.
K.R. Barua.
K.R. Borua.
K.R. Barua, Learned Counsel for the petition. On request, also heard Mr. R.K.T. Dev Chaudhary, Learned Deputy Solicitor General of India for the respondent 1 and 2. On request made by Mr.
L.C. Deva.
L.C. Dale, Learned Counsel for the respondent number 3. List the matter on
Because next Thursday, if it is convenient, my lord, 20th, next Thursday.
20, is it okay? 20, you're getting sufficient time, 1 week.
Yeah.
You can go to on 20 as part heard. I'm keeping it part heard.
And if I could request my lords to keep it at 2 o'clock, if that is convenient, my lords, at 2 o'clock.
Okay. We'll keep it in mind.
My lordship.
Oh, you junior, you
Yes.
can make the.
I'll make a mention.
Yes.
I'm deeply obliged, my lords. My lords have been extremely kind. So obliged.
Products on this item 1.
Yes.
Okay, Jorhat Municipal Board issued an NIP, and I had participated in that process in earlier occasions also, and my term will expire on 31/3/2025. Lordship, I have to pay 77 lakhs and odd for the tender period, and I have paid. Now, Lordship, during this period, Lordship will find that Jorhat, where my it is a Lordship collection of revenue from the bazaar, Sok Bazar area. Lordship will find that a construction activity is going on in the relevant portion of the Jorhat town. I had enclosed the photographs. Lordship will find at page. Lordship will can page 31. Lordship, flyover construction is going on in the area where my tender was issued and I'm working. Page 31, Lordship got it. Thereafter, Lordship, page 32 are the photographs where construction is going on. I cannot operate the market as allotted to, but I have to pay the amount. Page 33 is the next paragraph where Lordship, the flyover construction is going on. Lordship, thereafter, Lordship, I have filed application to the Jorhat Municipal Board that I have to pay the amount without operating the market because of these construction activities is going on. And there is a fire breakout in the area. And that is why, Lordship, I am not in a position to operate the market. And now, Lordship, the Jorhat Municipal Board again issued an NIT on 14/2025. And before that, on the basis of my application, report has been asked from the Jorhat Municipal Board has asked a report from the junior engineer of Jorhat Municipal Board, page 36. Lordship, got it? Page serial number 3. Due to ongoing construction of the flyover at AT Road, Sok Bazar.
1 minute. Page 36 is something different. Is a
Annexer, Lordship is taking 1490. I'm saying 1489.
No, I'm on 1490.
Lordship can see 1489. Same thing, 1489. Page 36.
Yes.
This is a report by the junior engineer. Lordship will last portion junior engineer. This is a report submitted on the basis of inquiry made by the chairman. Clause 3. Due to ongoing construction of flyover at AT Road, Sok Bazar, Jorhat, the roadside vendors at AT Road have been evicted by the authorities, as a result which there will be no collection of toll till completion of the flyover. And thereafter, Lordship, due to eviction of road vendors, JB Road, authorities' account of the ADRE examination daily toll could not be collected for 3 days. These are the report, Lordship. I have submitted a representation to the authorities. Considering the Lordship, the amount is 77 lakhs. I am paying the revenue. And now they are invited the NIT on 14/2025, page 41.
Page
41 is the original copy, Lordship, and the type copy is at 38, Annexer 9. That is, Lordship, in the original, the date was not mentioned, but it is 14/2025. And last date for submission was 1/4/2025, was period from 1/4/2025 to 31/1/2006.
26. Lordship, now I can participate in the tender process. There is nothing wrong on this. They have invited NIT not only for the market which I am operating, they have invited for 13 number of places. Page 49 is the relevant portion. Page
1 minute. Okay.
They have invited this NIT for not only my place, it was for 13 number of places under the Jorhat Municipal Board. Now, Lordship, my difficulty is, Lordship, I am paying the revenue. Considering the facts, Lordship, I file a representation to the chairman that consider page 57. My period is not expired till date, Lordship. Page 57 is my representation. At this stage, Lordship, I am not praying for stay of the tender process, nothing, Lordship. I pray, Lordship, the chairman should dispose my representation considering the facts. What relief I will get? Because of the construction activities, I have to pay 77 lakhs. It's more, almost, Lordship, 1 crore. And everything has been stopped. And I have to pay the revenue. At this stage, Lordship, I pray humbly that Jorhat chairman of the municipal board should be directed to dispose my representation.
Have you participated in the
No, last date is not expired. I will participate, Lordship. I will participate in that process. Only at this stage, Lordship, if they only I am the 13 number of places has been invited. Only one I have prayed that because of these activities, I could not operate it and I have to pay 77 lakhs. And for this period.
When did you make your application?
24 to 2025. Page 57. Only, Lordship, dispose this petition within 15 days. My term will expire on 31/3. 31/3/2025.
Yes, who appears?
I am appearing for respondent number 3 and 4, Lordship.
Who is the respondent 3 and 4?
Jorhat Municipal.
Okay.
Issued the NIT. I am appearing on behalf of Mr. PD Datta.
PD?
PD Datta.
Okay.
Lordship, Lordship, may issue notice in the matter, Lordship, will dispose of the representation. Dispose of the matter.
Okay, then what I'll do, I'm not issuing notice. I'll give you time to receive instructions.
Lordship, my submission will be, Lordship, because otherwise, Lordship, everyone will participate in the process. It will, Lordship, make complications. We have to make all the
That
parties.
is why I'm listing it on 18th.
Lordship,
Because 19th is the last date of submission of the. By 18th, you dispose of the representation. Okay.
Try to dispose it of. While the settlement carry on.
Before settlement, Lordship.
Before settlement, you dispose the representation.
Will not finalize. Tender process shall carry on.
Tender will carry on. Even the petitioner, if he wants, he can join the tender.
19th is the last day. So
19th is the last date.
Before that, they will dispose my representation, Lordship.
What bazaar is it?
The Chowk Bazaar, Lordship.
Chowk Bazaar and truck.
Jorhat Chowk Bazaar, first one. And next is truck. Same thing saying municipal board, on the next one is truck. Truck stand.
Initially, you were settled for
2023.
for 9/1/2023 to 8/9/2023.
That is also on basis of High Court's order. High Court order has said I'm the highest bidder. I have not been given the allotment order. High Court has given the order and thereafter I have been allocated for 8 months.
Okay. Heard Mr. S.K. Goswami, London Council for the Petition. Let's stop. Pursuant to an NIT dated 23/6/2022 issued by the Jorhat Municipal Board for settlement of Chowk Bazaar under the Jorhat Municipal Board for the financial year 2022-2023. the petitioner was given the settlement,
being highest bidder.
being the highest bidder for the said Chowk Bazaar for a period of 8 months with effect from 9/1/2003 to 2023 to 8/9/2023 by an order dated 6/1/2023. Stop.
Page 20 is the next order.
Page
28.
By another order, by another letter, by a communication dated 16/3/2024, issued by the chairperson, Jorhat Municipal Board. The period of settlement in respect of the petitioner was extended for a period of 1 year with effect from 1/4/2024 to
31/3/2025.
31/3/2025 by enhancing 2% of the settlement value at rupees 76,71,628.69. Correct?
Yes.
Stop. During the pendency of the said settlement, during the pendency of the said extended settlement, the Public Works Department of the Government of Assam started the construction of, what is it, flyover?
Flyover construction at a Chowk Bazaar area.
Started the flyover construction from Barwa Charayali to Bhogdoi Bridge
That's it.
on the Assam Trunk Road, Jorhat, thereby adversely affecting the Chowk Bazaar area, and as a result of which the petitioner could not collect the toll from the shops, thereby causing loss to the petitioner. Stop. Where's your first representation?
First representation Lordship will find at page 34.
Accordingly, the petitioner made an application for remission of contracted allotment amount on 1/8/2024 before the chairperson, Jorhat Municipal Board. Stop. Then it was sent for an inquiry.
Inquiry. And accordingly, report has been submitted, page 36.
Thereafter, an inquiry was
Directed.
an inquiry was
Junior engineer,
1 minute,
page 36.
conducted, and the junior engineer, Jorhat Municipal Board, submitted this report. When is the date?
Page, next page is date, Lordship. It was for the period 1/8/2024. It was reported, Lordship.
Hmm?
Inquiry is made on the basis of representation 1/8/2004.
Oh,
There is,
but when was the inquiry report submitted?
Lordship, in the report also there is no date. Page,
Submitted the inquiry report.
page 37 is the original.
Stop. Where it? The report was made in favor of the petitioner, correct? Was made in favor of the petitioner. Stop. However, comma, in the meantime, the is it the president,
Lordship, Chairman.
the chairman Jorhat Municipal Board issued another tender notice of market oblique stand oblique parking on
14/2/2025.
14/2025, including the
Chowk
area,
Bazaar.
including the Chowk Bazaar, stipulating 19/3/2025 as the date on which the tenders will be accepted. For settlement of the markets oblique parking oblique stand stop. Being aggrieved, the petitioner again made an application, made a representation on 24/2/2025 for extension of the lease period before the chairperson, Jorhat Municipal Board, Jorhat Assam. Stop. However, comma, as the representation for extension of the lease period made by the petitioner is yet to be considered, and as the and further, as the date of submitting tender is also nearing, as the last date for submitting the tender in terms of the notice dated 14/2/2024 is also nearing.
25.
Petitioner is before this court by way of the present petition. Stop. Para. Considering the facts and circumstances of the case as narrated briefly here and above, comma, the who's to suppose the dispose of the representation?
The three chairman.
The chairman, comma, Jorhat Municipal Board, oblique respondent number 3, is directed to dispose of the representation made by the petitioner on 24/2/2025 on or before 18th of,
Is that holidays are coming up?
yeah, that's why
If holidays are there.
18th, on or before 18th. So on 17th, 18th, you can do it.
Otherwise, Lordship will not
Finalize the
finalize with the settlement, Lordship.
No,
with
no.
respect to these two markets.
See, I've noticed something. Initially, it was settled with the petitioner for a short period of time. He was extended for 1 year. Now again, he wants extension. Are you going to keep on extending without any tender notice? This court has noticed something when I was just dictating now. Something is going on. On or before 18th of March 2024, 2025. Stop. Mr.
HR does.
HR Das, Leonard Counsel, appearing on behalf of Mr.
Mr. BT does.
Mr. B.D. Das, Leonard Senior Counsel, for the respondents 3 and 4. Shall also receive instructions. List the matter on 19th March 2025. Meantime, it's up to you.
Last date is 31. My time will expire on 31/3/2020.
But then your tender notice is, last date is 19.
19.
I'm listing on 19 on that day. If you are willing to contest, if you're willing to put in your tender, do it.
Same also, same, next also same Lordship, only parking space, 80 road, same place. Next one Lordship, same thing, same notice, same tender period, only the parking.
No extension orders.
Extension order also same.
No.
16/3, phase 20.
Do it. You can do it.
Phase 28 is extension.
NIT first, NIT was what? 23/6.
Same NIT. 6/1/2023.
For settlement of trucks done, huh? Instead of the Chowk Bazaar, settlement of trucks done. Here also flyover?
Flyover, phase 32.
And your representation?
Same Lordship.
So you want to carry on your business without?
No, Lordship. I have participated.
without making
Earlier
a
also I have
tender.
not been given Lordship. I have approached this court. Earlier also I'm the highest bidder. I have not been given.
After that, you were given for a few months.
Only 8 months. It was for 1 year. That is why Lordship, because of this, I have been given extension.
Then you're
because of
given
my
1 year extension.
1 year extension with increase of 2%.
Okay, fine. Now also you want extension for what?
Or extension or anything, Lordship, relief, everything, Lordship, 77 lakhs is not a simple Lordship. Anything, Lordship, they will pass the order.
Let them pass the order. On the respondent number 3. Is it 3? While disposing of the representation made by the petitioner, shall not be influenced by any observations made by this court.
Obliged.